Welcome to the British Comparative Law, legal, and thank you for joining us today. Unfortunately, I cannot join you via video because so I'm just talking on the phone. I'm very sorry for that. You are one of the 200 people attending this webinar today on recent development in international law in Myanmar. Only quickly, as I'm sure you are by now even too familiar with Zoom webinars, but just a reminder that people in the audience are not visible or audible, and the webinar will be recorded and uploaded on the BICOL website. Last January, the International Court of Justice ordered Myanmar to take immediate measures to prevent the genocide of the Rohingya Muslim minority. The decision resulted from the application to the ICJ by the Gambia, which sought proceeding against Myanmar for violating the 1961 Genocide Convention. The court extensively relied on the September 2018 report of the International Fact-Finding Mission, sanctioned by the UN Human Rights Council, which concluded that Myanmar security forces had committed violent acts with specific genocidal intent against the Rohingya. Alongside the ICJ, prosecutors at the International Criminal Court are also investigating crimes alleged perpetrated by Myanmar security forces against the Rohingya. But since Myanmar is not an ICC state party, the prosecution is going to investigate the situation in Bangladesh, which instead is a state party, arguing that the ICC has jurisdiction over Myanmar military officer because the crime of forced deportation of the Rohingya was completed in Bangladeshi territory. As you know, in November 2019, a pre-trial chamber gave the go-ahead for the prosecution investigation. So during this webinar, we will discuss the proceeding before the ICJ and the ICC, including issues of prevention and enforcement and national responses within Myanmar, as well as the situation in Rakhine State. We are also going to look as a comparison into the 1993 genocide case of Bosnia and Herzegovina versus Serbia and Montenegro, where the former accused the latter of perpetrating genocide against Bosnia Muslim during the 92-95 conflict there. So in this case, the ICJ concluded that Serbia had not violated the Genocide Convention, despite the International Criminal Tribunal on Yugoslavia giving extensive evidence and delivering damning judgment indicating otherwise. But enough from me, because we have an impressive lineup of speakers joined up from Canada, from Serbia, from Manila. So we'll now open the discussion with them. We're also taking questions from the audience, so please type your question in the question and answer box. You can also interact with questions that others are asking and upvote them. And then during the last half hour, our speaker will answer your question. So over to our first speaker, Marco. Dr. Marco Longobardo. It's a pleasure to have you. He's a lecturer in international law at the University of Westminster. Please, over to you, Marco.
Thank you very much, Irana, first of all, for the invitation. It's a pleasure talking about the ICJ case with the colleagues here, our audience, and I would say at the BICOL, even if not in person. So today, as requested, I'm going to talk about the pending case between Gambia and Myanmar before the ICJ. And in particular, I will talk about issues of the standing of the Gambia. So I'm not going to talk about the content, the merits of the allegation of the violation of the Genocide Convention. I think that Marko Milanovich will deal with this in more details. So which is the context of the issue? Allegedly, Myanmar is committing genocide against part of its own population on Myanmar territory. in a traditional bilateral, from a traditional bilateral perspective, we don't have an interest of any state in dealing with this situation, because the victims are nationals of the same state that allegedly is perpetrating a genocide, and because the alleged genocide is committed on the territory of that state. So it is a purely domestic situation from a very traditional and old-fashioned point of view. In this context, the Gambia, that is a state in Africa quite far from Myanmar, brought a case based on the 1948 Genocide Convention against Myanmar. The case was brought in November 2019, and the Gambia requested some provisional measures that were granted in February, if I remember correctly, 2020. So one of the issues that have been already addressed briefly in the phase of the provisional measures, but that will be addressed in the merits phase, is whether Gambia can bring a claim against Myanmar in such a situation where apparently Gambia lacks any specific interest. So Gambia based its claim on the fact that the Genocide Convention embodies, according to Gambia, obligations that are not bilateral in nature, but are obligations erga omnes partes, that is, obligations owed towards all the states that are parties to that convention. So that if there is a violation of one of the provisions of the convention, all the states parties have an interest in compliance with the convention. And apparently in the provisional measures order, the ICJ endorsed this view, even if it was done quite cursorily, since the issue will be addressed subsequently in the merits phase. So, which is the situation, I would say, what international says on this issue? The ICJ had faced quite an evolution in regard to these claims, these disputes brought by non-directly affected states. The first case decided by the ICJ was the 1966 Southwest African cases, in which the ICJ, 7 votes against 7, with the casting vote of the president, said that there is no actio popularis, no litigation in the public interest in international law, so a state that is not directly affected cannot bring a claim. That decision was severely criticized by many scholars, and the situation changed quite quickly. In 1970, in the Barcelona attraction case, the court mentioned the fact that was not really relevant for the case, but the court mentioned the fact that in international law there are some obligations that are bilateral in nature, but there are some obligations that are owed towards the international community as a whole. And in this second case, all the states and international community have an interest in compliance with this kind of obligations. This dictum was implemented by the International Law Commission in the 2001 draft articles on state responsibility. Article 48, paragraph 1 of the articles says that there are cases in which the invocation of responsibility can be done by a state that is not directly injured, and these cases are obligations owed towards the international community as a whole, that is obligations erga omnes, or obligations owed towards a group of contracting states, obligations erga omnes partes. The ICJ had the opportunity to pass a judgment on this in 2012 in the Belgium versus Senegal case, that was a case on torture. In this case, the court said that Belgium could bring a case against Senegal irrespective of any specific interest in the compliance with the convention by Senegal, since the Convention Against Torture embodies obligations erga omnes partes, so that all the states parties to the Conventions Against Torture could bring a claim. This is the precedent that has been used by Gambia in the Gambia versus Myanmar case. There was a very interesting debate by counsel, in particular Professor Pierre Dajan cited the Belgium versus Senegal case as the decisive case, and the case was cited in the order of the court about the provisional measures. So there are other elements, I don't have time to deal with that suggest that the ICJ made a shift towards allowing states parties to erga omnes partes conventions to bring claims even in the absence of a specific interest. For instance, in 2014, in the Whiling case, the ICJ didn't touch upon this issue, but apparently Japan didn't raise an issue of standing because they knew the court would have rejected it. So, which is my take on this topic? My take on this topic is that there is good, I think that the court in the merits phase would confirm the fact that Gambia has a standing. The convention, the Genocide Convention embodies obligations erga omnes partes. There is not a direct effect of states because Myanmar allegedly is committing a genocide against its own population. So all the state parties, in my opinion, can bring a claim. And this is very interesting as potential consequences for other situations. What I think the court should clarify better is the reference to the Belgium versus Senegal case. In Belgium versus Senegal, it is not correct to say that Belgium had no special interest. The case originated by a request of Belgium to surrender its Senabre that was suspected to have conducted torture. When Senegal refused to surrender its Senabre, Belgium asked the ICJ to intervene. So in that decision, the ICJ said there is no need to assess whether special interest exists, but in fact, the special interest existed. I think that in Gambia versus Myanmar, this requirement of special interest in the merits phase should be better addressed by the court. I don't think it's a bar from exercising jurisdiction. I don't think it makes inadmissible the case, but I think the court should clarify better the case. I would have far many more things to say about this, but I was asked to speak for 6 minutes. And so thank you very much. I look forward to your questions.
Thank you very much, Marco. This was an excellent start of this webinar. And again, I have to apologize to the audience because I'm only coming through a voice through the video, but unfortunately that's what we are dealing with during this time. So just a follow-up question to your presentation, Marco, which was really interesting. And do you think that standing based on obligation erga omnes partes may be recognized in the future in relation to other treaties?
Yes, I think there is a huge potential. So far in the ICJ case law, we have been clearly recognized the recognition that the Convention Against Torture and the Convention Against the Genocide embodies obligations erga omnes partes. But I think this can be applied to many human rights treaties. I think this could be applied in the future to international humanitarian law treaties like the Geneva Conventions, Common Article 1, the famous or infamous Common Article 1 suggests is, and to the Convention about Crimes Against Humanity, if it will ever be concluded. The fact is that we should emphasize that the ICJ can only have jurisdiction when states gave jurisdiction to it, where states consented to the jurisdiction of the court. And the issue of the interest to bring a claim is totally separate from this issue, as the court said in the case brought by Congo against Rwanda in 2006. So the first step is states must consent to jurisdiction to the court. Then we should ask which state can bring a claim. So far there is no, that I know, there is no state that has given the court jurisdiction over the International Maritime Law Conventions. So we have potentially the possibility for non-directly affected states to bring the claim, but we don't have, the ICJ has no jurisdiction. In the convention, again, the draft convention against crimes against humanity, on the other hand, there is a compromissory clause to the ICJ. So if states ratify that convention, and if there is no reservation on the specific compromissory clause, we could have cases in these scenarios.
And thank you, Marco. This really explains a lot. We will see what happened in this matter. And actually, this links very well to our next speaker, Dr. Marco Milanovich, who is a professor of international law at the University of Nottingham School of Law. And it's an honor to have you, Marco. You're going to tell us a bit more about the Bosnia and Herzegovina case before the ICJ.
Yes, thank you so much, Irene. Thank you for inviting me. Thank you to Bickel. Thank you to all of my co-panelists and to all of you for attending. It's a great pleasure to be here. Yes, I do want to talk about the Bosnian and the Croatian cases, genocide cases before the ICJ, because I think they are very instructive for the Myanmar litigation, and actually they allow us to predict with a great degree of confidence how this case will actually unfold and what needs to be done in order for it not to unfold in what would be the most likely sort of way. So this is what lawyers normally tend to avoid to do, like predict the outcome of a case, but that's what I'm going to do, basically. And that's not because I have a crystal ball, but because the confluence of three factors that were key in the Bosnian and the Croatian cases will probably unfold in the exact same way in the Myanmar case on the merits. And what are these factors? First, that the court only has jurisdiction over the crime of genocide. It does not have jurisdiction over any other international crime committed in Myanmar, specifically crimes against humanity and war crimes. That's because the court's jurisdiction is based on Article 9 of the Genocide Convention. So as soon as the court finds that any given act in Myanmar was not genocide, but was only a crime against humanity or a war crime, the court cannot examine Myanmar's responsibility for that crime. And that's the exact same pattern that we had in the Bosnian and the Croatian cases, right? That the court's jurisdiction is confined only to this one crime. The second problem is that crime is defined in international law in a very narrow way. That to commit genocide, you need to have a specific intent to physically or biologically destroy the group as such, in whole or in part. And that definition of the crime has been interpreted, has been written in a very narrow way, and then has been interpreted in a very narrow way, so that the vast majority of atrocity crimes that happen in the world do not legally qualify as genocide. And there's a disconnect between the public perception of the crime and the legal definition of the crime. People will talk about genocide in Darfur, genocide in Cambodia, genocide here, genocide there, but actually it's highly unlikely for international courts to actually determine that genocide happened. So in the former Yugoslavia, for instance, the ICTY only found genocide being committed in one specific place in one specific moment in time, and that's the 1995 Srebrenica massacre, when the Bosnian Serbs killed 7,000 Bosnian Muslim men and boys. All of the other crimes in Bosnia, all of the other crimes in Croatia were not legally genocide, okay? And that's a huge problem for Myanmar, for the situation of the Rohingya in Myanmar. Related to that is really the key point to understand here with regard to the definition of the crime. It's not enough to prove that people, the Rohingya people, were targeted because of their ethnicity or religion. That's not a genocide, okay? What Gambia needs to prove is that the intention of the authorities of Myanmar was to destroy the group as such, okay? So if you prove discriminatory intent, that's a crime against humanity. That's not genocide. Okay? So that's the key point, the narrowness of the crime and how the court also has interpreted that crime in the past. And the third key point is fact-finding. In the Bosnian and the Croatian cases, the court, the ICJ, had the luxury of having a criminal tribunal that already examined all the facts. That was the ICTY. And effectively, if you look at the Bosnian and the Croatian judgments, what the court did was a copy-paste job. It, said, this is what the ICTY found, and we agree with the ICTY. Okay? They never disagree with the ICTY. If you look at the extent of the fact-finding, the independent fact-finding that the ICJ did, it was pathetic. There were like a couple of witnesses heard. They didn't say anything we didn't know before. There was some documentary evidence being produced about the key issue of the relationship between Serbia and the Bosnian Serbs and so on, but nothing came out of it. Okay? That's because traditionally the ICJ is not the best fact finder. All you do before the ICJ is one party, puts forward a huge bunch of papers, the other party puts forward an equally big bunch of papers, and the court says, I find this one more persuasive. So the court is not used to doing extensive fact-finding, hearing witnesses, going into details about the mens rea of individuals and so on. Now, when you combine all of this together, that means that the most likely outcome of the Myanmar case will be the same as in the Bosnian cases, and same in the Croatian cases. That the court will say, well, terrible things have happened probably in Myanmar, but we need clear and convincing evidence, very high threshold, that the government of Myanmar, the authorities who acted on behalf of Myanmar, had genocidal intent. And we don't think that's the only possible explanation of what happened. It could be that we only had crimes against humanity. By the way, when I say only, I don't mean that crimes against humanity are morally any less bad, even though people often devalue crimes against humanity compared to genocide. They're equally bad, it's just that the court does not have jurisdiction over them. So that's the most likely outcome of this case, that 5 years down the line, I don't know, 10 years down the line, whenever the case ultimately gets decided, and that will depend on a lot of things, that the court will say, genocide probably didn't happen, and therefore there's nothing to be decided on in terms of Myanmar state's responsibility. So the question of how to avoid this, if you are litigating on behalf of the Rohingya, whatever, is the most tricky one. There is not going to be an international criminal court. Even the case that is going to be heard maybe before the ICC on this is not going to capture this stuff. Yeah? So whatever fact-finding happens has to happen before the court. The various, the fact-finding missions, Human Rights Council, whatever, they do not contain what the court needs to decide this case. So what Gambia needs to do, and probably already knows it needs to do, is to take a very different proactive approach to fact-finding, to establishing the evidence for genocidal intent, compared to the litigation teams in Bosnia and Croatia. And they're trying to do something like that. So last month, Gambia launched proceedings before a domestic court in the United States against Facebook, requesting Facebook to disclose voluntarily or not posts or communications, maybe even by high-ranking officials of Myanmar that might show evidence of genocidal intent. But we really do not know whether that such evidence is there. We know that there is evidence that Rohingya were targeted because who they are. We do not know whether actually there was genocidal intent. As far as there's certainly no smoking gun that I'm aware of. Now, whether that type of proactive approach before the ICJ results in anything, we shall see. But if I was to bet on this, knowing what the ICJ is like, I am, let's say, 70% certain that the outcome in the Myanmar case will be the same in the Bosnian and the Croatian cases. Now, what that means for the advocates for the Rohingya is I think there needs to be a lowering of expectations. There needs to be understanding that this case is being used for instrumental purposes to achieve some kind of focus on the situation in Myanmar right now, to exert pressure on the government of Myanmar right now, but that they should not expect this case to ultimately bring some kind of justice writ large. And the Bosnian and the Croatian experience were a huge lesson in why this should not be done, and how the enormous amount of disappointment that the Bosnian judgment, which was entirely predictable, produced in Bosnia among victims and so on. The sort of triumphalist proclamation of innocence in Serbia of the outcome of the judgment, even though Serbia was involved in an enormous amount of bad things in Bosnia. The front paper, the front pages of the newspapers in Serbia the day after the judgment were, "We are innocent, we are not guilty," said the World Court. And so the Rohingya activists need to understand that this is going to be the most likely outcome, and they need to calibrate their strategy, their communication strategy, bearing in mind that this is going to probably be the ultimate result. And now how that's done is not for me to say exactly, but we need to appreciate sort of the relative possibilities of what this case might achieve. Thanks.
Thank you very much, Marco. Of course, having this level of comparison is extremely important, because, of course, those are very, very rare type of cases, and I'm sure that we will go back during the discussion on the genocidal intent and how this can be proved, as well as on an issue that you mentioned, including the pressure on the Myanmar government, strategies for the Rohingya activists. But just maybe one quick question, because of course you mentioned that it's not realistic to expect completely different decision by the ICJ. But do you think that it is realistic to expect a different approach from the ICJ compared to the Bosnian and the Croatian cases, in light of changes to the composition of the bench?
No, for various reasons. One is that actually, I think that the court's approach in the Bosnian and Croatian cases was legally correct. You know, disappointing maybe for various reasons, but legally correct. That's one reason. The second reason is that the court very rarely departs from its prior jurisprudence and really needs weighty reasons to do so. And it would look terribly inconsistent for the court to do something in the Myanmar case that it did not want to do in the Bosnian and Croatian cases. And third, the issue of the composition of the bench more specifically, there's the whole question of who are these people who sit on the ICJ? How are they elected? What's their profile? And if you look at their profile, most of them have either sat on the earlier, well, some of them have sat on the earlier cases. For example, Judge Tomka, let's say. Others are embedded in this whole system. They were members of the International Law Commission. They, like Judge Robinson, they sat on the ICTY. He's not gonna contradict the findings of the ICTY implicitly by doing something completely different in the Myanmar case. And generally speaking, these people are not, you know, to use the sort of very, very intellectually impoverished term, judicial activists. That's not what that's not who states appoint to the ICJ. Of the 15 judges on the ICJ, there's one that I can confidently predict will rule in favor of Gambia. That's Judge Trindade from Brazil. Everybody else is going to be, it's not going to be like an 8-7 split. It's going to be 13-2 or 14-1, something like that. And unfortunately, unless Gambia is able to provide much more evidence of genocidal intent that we have seen publicly so far, that's going to be the likely outcome. Sorry to be a downer, by the way.
No, Marco, thank you very much. And you are not a downer. I think this is a very this is like a brilliant insight into the proceeding of the ICJ, and also what we can expect from that. But again, I'm sure that we will go back there during the discussion, because this is one of the key issues, and we're going to have a question from the audience as well. But I think we can move to another proceeding at the international level that you just mentioned, which is the one before the International Court, the International Criminal Court, and we have an expert on that as well, with Dr. Priya Pillai. She's actually joined us from Manila today. She's an international lawyer and head of the Asia Justice Coalition Secretariat. So please, over to you, Priya, with some insight on the ICC proceedings. Well.
Thank you so much for the introduction, and thank you to BIICL for inviting me on this amazing panel with this fabulous set of speakers. I think we got a very sobering assessment with the last speaker, Dr. Milanovich, and I think let's pivot now from state responsibility, which is what is the crux of the ICJ, to the whole question of international criminal responsibility and individual responsibility. I will give you just a little bit of a background and chronology of what is going on at the International Criminal Court, and then hone into a few issues that I think are important for the case with Myanmar and Bangladesh, but also for other cases. So I think just a little bit in terms of the background. So the International Criminal Court currently has an investigation going on in the situation in the People's Republic of Bangladesh, the Republic of the Union of Myanmar. This investigation was approved on the 14th of November, 2019, the same week, incidentally, that the ICJ Gambia case was filed and that a universal jurisdiction case in Argentina was also filed. So a very momentous week in November a few months ago. At this point, the case before the ICC has been initiated by the prosecutor. And what this means essentially is it's quite an unusual case because the prosecutor has chosen to go down a path where Myanmar is not a state party to the International Criminal Court, whereas Bangladesh is. Bangladesh signed up in March 2010. And so the prosecutor's strategy has been to look at specifically the issue of a crime against humanity of deportation, which implicates crossing an international border, and to therefore assert jurisdiction through this one, crime against humanity, to then say, there have been allegations of crimes committed, and though Myanmar is not a state party, because Bangladesh is a state party and part of the crime continues or has been completed in Bangladesh, therefore the court can assert jurisdiction over this case. So it's quite an unusual case, and it's a different approach as well, even within the context of the ICC. I'll highlight 3 milestones that I think are really important in terms of the case documentation and how the case has gone forward. The first one, of course, is, again, quite an unusual approach where the prosecutor, and I think, if I recall for the first time, has used Article 19.3 to ask a pretrial chamber for approval in terms of jurisdiction. And this was, again, seen as quite unusual. It's a different sort of approach that the prosecutor has taken. And the pretrial chamber on the 6th of September 2018 came out with a decision saying, yes, there is jurisdiction and you can move ahead. So that, for me is one important milestone. The other very important milestone, and I think, sometimes as lawyers, we don't pay enough attention to this, is the fact that we've had a number of victims' representations that have been filed before the pretrial chamber for a subsequent step. And these representations were filed, over a few months, and the last one was 31st of October, 2019. And this is, again, I would use the term survivors, but using the Rome Statute, using the terminology that we have, this is, again, a very important milestone, I think, that we need to take note of. Of course, the third decision, which I mentioned at the beginning, was the decision by pretrial chamber 3, which was the authorization of the investigation. So essentially, that the pretrial chamber has found that there's reasonable basis to conclude that crimes have been committed, and that there is a case to be made out for jurisdiction, and therefore the prosecutor then moves to the next stage, which is the investigation stage, which is a much higher stage in terms of the investigation that is done, the work that is done around the case, the evidentiary issues. So it's really the next step up in terms of the case moving forward. I think for me, I would really flag a few issues. One, the first really important point here is on jurisdiction. And I think, to look at, say, the comparison with the ICJ and the focus on genocide as the crime that is before that court, the question has been, okay, so is the focus of the ICC only deportation? Is that the ambit of this case? Does it go beyond that? Is there any possibility that it goes beyond that? I will basically, emphasize the fact that the first decision that I mentioned, which was on jurisdiction, the pretrial chamber there opened the door a little. It actually told the prosecutor, well, you've looked at deportation, and yes, there's the crossing of an international border, but using the same methodology that we look at in terms of asserting jurisdiction, you can also look at inhumane acts as crimes against humanity. You can also look at persecution under Article 7. So the pretrial chamber in that instance has opened the door and said, you don't need to restrict yourself only to deportation. Jurisdiction might be able to be established even through other crimes. Now, fast forward to the 14th of November and the decision that the pretrial chamber 3 came out with, authorizing the investigation. It's actually gone further. So if you look at the 14th November decision, it basically says, well, you can also consider any other crimes within the context of Article 5, which, as you know, is war crimes, crimes against humanity, aggression, and genocide as well. Of course, probably the court hasn't gone to the extent of naming genocide either in terms of the factual issues or, what the court felt was in front of it and what it directed the prosecution to do. But it's just to emphasize that the door is open. It's now, the ball is in the prosecutor's court. It is up to her to assess the evidence, to assess the facts, to make that determination whether she has enough on board to actually go down the path of looking at other crimes as well, not just crimes against humanity. So I think that's one really important point that I'd like to make. The other point that comes out from the 14th November decision also is on the material scope of this investigation, which is, as I'd mentioned, other crimes against humanity and any other Article 5 crimes as well. The other point that was raised was the prosecutor had requested authorization from 2016 October onwards, which is the same time frame before the ICJ. The pretrial chamber has actually changed that to 2010, based partly on victims' representations as well. So again, a difference in terms of the temporal scope of what the prosecutor can look at. The other point, which I think especially with looking at advocacy around this issue, the UN Security Council referral. The pretrial chamber again has, in this 14th November decision, raised the fact that would not, moving ahead on an investigation, would not preclude a UN Security Council referral, however difficult that may be. So again, I think legally, in terms of laying out very clearly in this decision, certain points that are really important points to keep in mind moving forward in this case. I think with that, I'll just flag a few other points, and I'm sure this will come up for discussion. One is, linked to our two previous speakers and the ICJ case. The fact is that at the ICJ, it was argued by the agent for Myanmar that there's no threshold for genocide, but yes, maybe crimes against humanity were committed. And we have an internal military system that is going to deal with that. So what impact does that have in terms of what is before the ICC? Because the ICC is looking squarely at crimes against humanity. So, I think it's interesting to make some of those connections as well. As the previous speakers have mentioned, the whole issue of fact-finding. The International Criminal Court is looking at this case, a specific area, a specific part of it, but I think not to forget that we also have the International Independent Mechanism for Myanmar, which is again the fact-finding or the mechanism that is supposed to consolidate and analyze and keep evidence of these crimes as well. So we've got a few different issues as well playing out in parallel. But of course, the other thing that I would also highlight is the whole issue of state cooperation or lack thereof, especially in this case, where you have crimes that are being looked at both sides of the border, and in terms of actual access or cooperation from Myanmar, that is unlikely to come through as well. So I think I leave it there, but there are many points of discussion, I think, arising out of the ICC case as well. Thank you.
Yes, Priya, thank you very much. And yes, of course, there are many issues, but thanks for explaining this point, especially on the jurisdiction, on the material scope, on the investigation, and as well as on the point of the UN Security Council referral. And you also touch on the potential overlap and synergy between the ICC and the ICJ case, and I think we can talk about that a bit more later. But one thing that you mentioned, maybe you can just develop a bit more, just maybe 1 minute or so, is on the role of the independent investigative mechanism for Myanmar. So what do you think is impact on the ICC case could have, if any?
I mean, I think the IIMM, I mean, it's interesting in terms of timing as well, and sort of the parallel movement of the ICC case. But, I think keep in mind the IIMM, there are a few things to keep in mind. One is that it has inherited the fact-finding missions, evidentiary material, and all the material that has been collected, in 2018, 2019, that went into the IFFM report. So that's the one, including the confidential informational material. So there's essentially been a passing of the baton, or the IIMM now has this cache of information that is available to it. I think the thing to keep in mind also is that it has started operation quite recently, as of I think August or September last year. It's issued its first bulletin. If you look at the terms of reference of the IIMM, it's very clear in terms of what it's meant to be looking at in terms of evidence, how it's supposed to be approaching it in terms of standards of human rights law, that it's supposed to collect, collate, analyze this evidence for use in a national, regional, or international court. So essentially, it's going to have to, keep this evidence and ensure that it gets used in a court as well. And of course, the problem also will be for the mechanism, access to Myanmar and access to information. And, as Dr. Milanovich has pointed out, there is a case now in terms of getting information from Facebook as well. So I think there are multiple fact-finding initiatives in a way. And it's all sort of coming through at the same time. So in terms of sequential, the fact that the ICJ could rely on the ICTY or another tribunal, that right now is not the case. So that makes it more complicated, actually.
Yes, true. And this I think is an interesting point. The interaction between domestic and international mechanism. And actually, this links well, because we are now moving, let's say, from the international side more into the national side, to say so. And we have some experts on that, starting with Yi Toon, who is a lecturer in law based normally at Harvard Law School, but she's actually joined us today from Vancouver, so it's in the middle of the night there. Thanks for the extra effort. And last time we met, it was actually in one of the tea shops in Yangon, because we were both based there, working there like a few years ago. Yes, over to you, Yi. It's a pleasure to have you.
Thanks, Irene. It's great to hear from you again and to be on this panel along with my esteemed co-panelists, and to Michael for organizing this great panel about my country of birth. So I'm going to tell you a little bit about, as someone who's from the country and who's worked on international human rights globally for more than 20 years, and this push for international accountability for Myanmar has been a long time coming. But really for me, I want to talk about what's happening, also the reaction inside Myanmar, the domestic reaction to this, what has led to this current reaction, and where do we go from there. So as Irene had said, for a country, and for anyone who's on this panel who's familiar with Myanmar would know that, it's a country that has a long history and a human rights record that's mirrored with violations, systemic oppression of its ethnic and religious minority communities, not limited to the Rohingya community, but also variety of communities, that is still to this day, as we're speaking, very much in an active armed conflict in its western states of Rakhine State, Chin State, as well as in the north with Kachin and Shan State fully engaged in armed conflict. But what's interesting is that, for those of us who've long worked for human rights and rule of law in the country, these progressions, whether it's at the ICJ level or at the ICC level, or the establishment of an independent mechanism on Myanmar, or even the universal jurisdiction cases. These are all great milestones that we've been striving towards. But the reaction towards the international accountability has been somewhat of a negative one domestically inside Myanmar. And when I say domestically inside Myanmar, I'm really speaking to actors such as the military, the civilian government, and also the non-state actor movement, such as the nationalist movement that has been sweeping the country since 2012 when it started opening up. So, you know, it's surreal for me speaking as someone, you know, while my colleague who's going to speak right after me, Yasmin, was in The Hague in December 2019 at the proceedings at the ICJ trial that the Gambia was bringing forth against Myanmar. I was inside Myanmar in Yangon myself, working with different human rights defender and civil society organizations. And to see that, you know, in the same sites such as places like Mahambanula and the site of the heart of the capital, to see jumbotrons going up, to see mass rallies gathering, you know, not to protest and call for justice on behalf of survivors and communities whose rights have been violated, but really to really view this genocide trial and this narrative that the international community, which doesn't understand us, is bringing shame, is, you know, and to have the state agent who Priya just mentioned earlier, Aung San Suu Kyi, who's an icon and a figure of reverence in a country like Myanmar, to go to The Hague, and it became this sort of national fervor around it. And I think the reaction or the backlash against the international community has a lot to do with the framing of this issue. Those of us on this panel and many of us who've worked on human rights have been really focusing on the violations, the evidence, the documentation that's been widespread, not just limited to the Rohingya community, but it's been ongoing for decades against different communities, from the Kachin to the Shan to the Karen, the Karenni, and the list goes on in a country that's never known peace. But most of us have been focusing from the viewpoint of human rights, whereas the conversation and the narrative and the framing of this whole incident from the clearance operations against the Rohingya, that narrative inside Myanmar is very different. That narrative is around, this is a sovereign country who is simply acting against terrorist attacks that had attacked a nation. And it would be astounding to think, why would something like this be resonating with country that has languished, or a country and the people who have really been oppressed by the military regime that's still continuing to hold power? But when you really think of why that resonates, it requires us to sort of take a step back, not from this moment in time, but even to explore back to the decades of military dictatorship, the propaganda and the machinery that's been in place, but also looking at even the narratives that were there as the country emerged. So I, as Irene was saying, had gone back to my country of birth in 2012. You know, it was a time of great optimism for those of us from the country. People were freeing political prisoners. People could gather in public spaces. You could talk about human rights. These were things, freedom of expression to a certain degree was restored. There was free press for the first time in my entire lifetime, much less, you know, my family's lifetime. So these are huge causes for optimism. Yet at the same time, there was something insidious brewing that people like myself started realizing, which was, you know, the freer political space also meant there were certain actors such as this ultra-nationalist movement led by nationalist monks like Wirathu, who's, you know, pegged himself as the Buddha's face of terror, who were now using this freer space to mobilize through the country, who were using new technology like social media, which, you know, my colleague, Dr. Milanovich mentioned earlier about using social media to permeate and reach into the masses. This notion that with great change and with the country opening up to the international fora, what we were having was this identity crisis, that Myanmar's race and religion was under threat. Under threat from who? Very unclear, but really it says that without action from the Buddhist majority, or without action or defense from the military, that race and religion would be attacked, and that there would be enemies within and enemies without. For someone, it sounds like conspiracy theory, but the same message, actually, the same narrative has been peddled down in the generations of military propaganda. But the difference now is that it's not just the military junta that's pushing this narrative. The narrative is being carried forth by figures that are non-state actors, such as these nationalist movement, and it was being permeated and reaching the masses using new tools. You know, not only were you having freer space, so you've got these mass rallies that were taking place all over the country, but you also had people into their smartphones, reaching in through social media, this constant stream. And in the lead up to the first ever democratic election in recent history, in the 2015 election, where the civilian government was elected for the first time, in the lead up to that, when I was inside the country working with human rights defenders and with the communities, the one message that kept coming up from the incumbent party, which was a quasi-military party that was going up against the National League for Democracy, as well as the nationalist movement that were really, they didn't say who they were supporting, but it was very clear that them and the military and the quasi-civilian were very much in the same coalition. They didn't tell you which party to vote for, but really was very clear that, and it was explicitly said that a vote for the National League for Democracy and Aung San Suu Kyi and democracy meant that you were voting for a government that was weak on immigration, it was weak on security, it was weak on borders, and it could eventually lead to citizenship rights for Rohingya brothers and sisters. So these were the sort of populist movement that was taking shape. And, dismiss it as it may, it was extremely potent and extremely powerful, because for the first time, and to the travesty that I think, it's the first time in the history of Myanmar that a party like National League for Democracy, as well as along with other political parties, stopped running candidates who were of Muslim religion. It was the first time the parliament sat without having a Muslim member of parliament since the country came to being. So I think we can't just dismiss why this narrative and why this messaging is so potent. Fast forward, despite these tactics, the National League for Democracy gets elected, civilian government gets sworn in. Within months after they get sworn in, you have the first attack from the Arakan Rohingya Salvation Army, or ASA. Therein starts this clearance massive operation that's led to, almost 1 million of the Rohingya refugees being pushed to a place like Bangladesh. And then we've got inside the country this narrative again, as more and more human rights reports emerge, as more and more documentation emerge from the fact-finding mission, which I think, my sister Yasmin is going to present in a little bit. As these documentation emerge, people kept saying, the mass communication inside the country is that the international community is biased. They are not listening. They don't know that this is a terrorist attack and that we need to do counterinsurgency, and that, do not trust whatever it's out there in the fora. And that therein starts the shift, right? So you've got the civilian government and the military sort of negotiating this delicate balance of power between the two of them. And at the same time, now they're confronted with this sort of scrutiny, which just kind of brought them closer together, if anything. And then what happens now is that you see them withdrawing, which is why, as my colleague Priya was saying earlier, not cooperating with the fact-finding mission, not participating, disengaging. In fact, the ICJ is the first time that Myanmar has appeared and engaged with the international community. The special rapporteur on the situation of human rights in Myanmar initially was welcomed, allowed to visit the country, allowed to meet with people, but then suddenly, because of these kind of withdrawal phase, people like herself was no longer welcome as well. And, the international accountability is incredibly threatening. I think that, be whatever the outcome may be at the ICJ or the ICC or the universal jurisdiction case in Argentina, one thing is for certain: for a military and a regime that has operated with impunity for decades, this is the first time potentially of having the consequences of their violations addressed. And that's potent. And that has actually led to the domestic transformation or the domestic changes that people like myself think that, the international community can't underestimate. Why? Despite the symbols, maybe the impact, but it is leading to change. I'll give you a specific example. Before the ruling on provisional measure and before the hearing at The Hague, it was the first time ever that there was a military tribunal that looked into a massacre in Rakhine State, known as the Indian Massacre. They sentenced 7 soldiers, 10 years for killing 20 Rohingya men and boys. That's the first time. And they admitted that this was a war crime and a crime against humanity, and that the military was going to court-martial. Of course, a gesture like that would have been unfathomable in the decades-long conflict against different communities, but that was made possible because of the international scrutiny and because of that attention. Similarly, after the ICJ found the provisional measure and made Myanmar submit its report, which, the first report's been submitted in May, in the 1 month leading up to that, we've been talking a lot about hate speech. In fact, at my International Human Rights Clinic where I work at Harvard Law School, we're going to be coming out with a forthcoming publication that we were working with civil society in Myanmar that looks at the narrative of hate speech and things like that. And this has been documented in the fact-finding mission as well. A month before they had to send a report to the ICJ bench, all of a sudden the presidential office issued a presidential offer, a presidential order saying that no members are supposed to be participating in hate speech. So I think it's these incremental changes that we're starting to see domestically, but that doesn't mean that we can say, eventually there's going to be rule of law and that's going to be welcome, because it isn't. And I think I want to end with, we've talked a lot about the international fora and the reaction inside, but I really just think that, if the international community is looking to the signaling from the likes of Aung San Suu Kyi or the military or the civilian government or even the ultranationalists, you'll say that it's a rejection of justice, it's a rejection of international accountability. But when you really dig deeper, this move is welcomed by people in the diaspora. This move is welcomed by people in the refugee community, also other ethnic communities. In fact, when Yasmin and other Rohingya brothers and sisters were at the ICJ proceeding, the people who came out in support were other ethnic communities who themselves have been subjected to these violations since 1962 onward. The same goes, because of the push for justice and accountability, CSOs inside have been, communicating secretly and working with the fact-finding mission, the IFFM. These are not Rohingya groups themselves. These are people who are from different communities. They're taking great risks upon themselves because they want to see justice done. And I want to refer to even the youth groups nowadays. They are coming out with grassroots campaign trying to say that for the 2020 election, we want Muslim members to be allowed to run. We want Muslim people to be allowed to vote. And we want peace. And people are mobilizing around it. So I think that, it's one thing to think about perhaps the civilian government and the military, but I think the people's voices, where it really matters, that's being, there's this sense of optimism and movement. And I hope that those are the community that the international community and the people who are moving in this international accountability doesn't forget, the survivors and these communities that stand behind them. So I'll stop for now and hand it over to others.
Thank you very much. It's so important to hear about your experience, your point of view, and what's actually going on at the domestic level. And just very quickly, I'll ask you to maybe just reply in 1 minute or two. I would just wonder, because you mentioned the hopes there were after the November 2015 election. So I would. The 2020 election and what the future holds for Myanmar.
Best case scenario, I would hope that the nationalist fervor that swept Myanmar in 2015 election or the lead up to it would be tempered. I'm hoping that these voices that are coming out from the civil society to the youth groups that are demanding, I hope that those will be the voices that the party really, with a name like National League for Democracy, really thinks about the principles of democracy. And my hope would be that, there's a real chance to move away. I think even in the 5 years, this push for accountability has brought them closer. But when you think it before the ICJ proceeding and the ICC, there was actually quite a lot of tension between the military and the civilian government. The tensions rooted in things like the fact that the civilian government's been trying to enact constitutional law reforms in country, and they were really stalled and facing opposition. So I think remembering those principles and remembering what kind of a country I would imagine, that would be the guiding hope going into the 2020 election, to make sure that all the people from the internally displaced people in the north to the west, they're allowed to vote somehow. At the same time, people who are affected by conflict has a say at the peace table. So I think those would be the key principles that I would imagine going into 2020. But it could go either way. If 2020 election is a repeat of what had happened in the lead up to 2015 election, and now hampered with this international scrutiny, I hope that that's not the case. I would imagine that with the mobilization and with all of us focusing on it, that it would be the former rather than the latter.
Mm-hmm. Yes, yeah, thanks. And but we want to hear more also about the specific view of the Rohingya community, as well as the situation within Rakhine State. And it's a great pleasure that we have today with us Jasmine Hulla, who is the president of the Rohingya Human Rights Network. Also join us from Canada. Over to you, Jasmine.
Hello, everyone. Thank you very much, Irina. I'm very, very grateful to be part of this discussion. So thank you very much. I am going to definitely depart a little bit from, all the legal discussions here, and go into a little bit more, information and the thoughts and the ideas that are brewing within the community, as well as something on the independent international fact-finding mission. So the mission itself had first released its report on the Rohingya in September 2019, that it had found genocidal acts in Myanmar's 2017 clearance operations that killed thousands and caused many more, more than 740,000 Rohingya to flee for their lives to Bangladesh. We're only a few months away from the third anniversary of the brutality, but to this day, my family, my people, and many of those who are remaining in Rakhine State are still living in fear. The inaction or the willingness to hold Myanmar accountable has been very difficult. It's a very difficult concept to grasp for many Rohingya advocates, despite various initiatives, in terms of the international justice mechanism and the progress that we've seen so far. The day-to-day lives of the Rohingya refugees and many of those in Rakhine states are still very vulnerable. Adding to that, the impact of the pandemic that is really felt all throughout the world, the internet ban that has lasted several months now, and the existing culture of impunity as a whole, the harsh reality of the lives, the fact that there are no humanitarian groups that could reach or could work inside Rakhine State. All of this had kind of bunched up together, and it forces us to kind of rethink a little bit when we see the initiatives that are taken in various different ways, whether it be at the International Court of Justice or the International Criminal Court or the universal jurisdiction. The hope or the excitement are a lot less now than before, due to various reasons. It could be the lack of understanding, the excitement, the hype of the moment as well. But now the reality is felt. The harsh reality that we live on a day-to-day basis is really seeping through, and we're seeing that the initiatives that are taken by the international community might not be as drastic or as immediate as we were thinking before. Take the IDP camps, for example, in Rakhine State. There are about, a few 100,000 people living in squalid conditions and cramped in that, tiny space, with little water and food. And some of those, are now facing the risk of the widespread of the pandemic without actually having the access to hospital or testings in general. There are also incarcerated populations in Myanmar, for example, that are also at risk of the outbreaks because of the various human rights abuse that is ongoing within the prison. And these are the population that are bearing the brunt of human rights abuse as we're speaking, and worse so because of the neglect on the part of the international community, because everyone is sort of absorbed into their own, I guess, interest of the nation, of their own people. And oftentimes, there are all these various different attacks and heavy use of artilleries that are widespread within the Rakhine State that is basically being ignored completely or partly. My own family, I have to tell you, have been victims of many of these arbitrary arrests, and these are very much rooted within the systematic deprivation of citizenship and basic human rights, as well as the systematic alienation and erasure of the ethnic identity or indigeneity, and broadly, any link that we have towards our homeland for centuries. Now, it is probably also a good reminder to the audience that many crises that are manifesting right before our eyes to this day, waves after waves of boat people that are fleeing destitute lives in Bangladesh refugee camps or in Rakhine State, are not recent developments. These didn't just happen in 2017. It's a combination, and it's the red flags that the international community has long been informed of, but decided to not do anything about it, or decided to do very little about it. This is very well planned, strategic uprooting of a group of people undesirable to the existing power within Myanmar, because of our existence alone within Rakhine State will invalidate some sort of, economic plans to exploit the areas and resources to garner absolute power that they're looking for. And when nationalization took place in Myanmar, the majority of resources and management of those went on to be controlled by the military, as pointed out by the missions report, as well as on the missions report on the military's business ties, that Myanmar's military has used its own businesses, foreign companies, arms deal to support brutal operations against ethnic groups that constitute serious crimes under the international law, bypassing civilian oversight and evading accountability. It also mentioned that this is all part of the deliberate, well-planned strategy to intimidate, terrorize, and punish a civilian population. This is not exclusive to Rohingya, just as Sister Yi had mentioned before, but it encompasses all of the ethnic minorities, regardless of whether or not they took up arms. It is probably also noteworthy to point out that even with the various international cases that are ongoing, Myanmar continues its oppression of the ethnic communities. Violations of ceasefire is ongoing, even though there is a new ceasefire that was signed in terms of how to deal with or the in effects of the COVID-19 widespread of the pandemic. The ceasefire is never, it's always violated by the military, and unfortunately, it was never signed with the Arkan army, who is, often seen clashing with the Myanmar military, and so innocent civilians are still having to flee every single day, and these heavy use of the artilleries just days after provisional measures by the ICJ, suggesting that the Rohingya are a protected group is a very, very clear example of how very little Myanmar military actually take into account the various accountability mechanisms that are ongoing. Since Myanmar is a signatory to the UN Genocide Convention, it is obliged to at least adhere to, the fact that we are supposed to be protected. But even with that, it has been conveniently dismissed. The fact that they should not kill people, they should not commit crimes against humanity or commit anything that is close to crimes against humanity or genocide. It's often dismissed by the authorities within Myanmar as the approach to resolve or prevent further atrocities committed by committed against innocent civilians. Oftentimes they would vilify the victims and quash their claims that, by creating various different entities to gaslight the community, as we've seen in the Independent Commission of Inquiry that was supposedly, investigating the case of the clearance operation. And it concluded, unfortunately, no one has seen the actual copies of the entire report yet, because it's never been publicized to the best of my knowledge. But the Office of the President of Myanmar actually released a short summary of the report itself, and says that the military, if it did anything at all, it would not be genocide. It would just be merely be a war crime or crimes against humanity. And the claims that the crimes related to sexual and gender-based violence took place was concluded that it cannot be verified at all, and it would not be further investigated. It's probably worth mentioning that the report is kept secret to this day, and at the same time, the survivors of mass rape and sexual violence, who have been interviewed by many humanitarian organizations, as well as the fact-finding mission on Myanmar, were never interviewed by the commission itself. In fact, the mission, the fact-finding mission, reported to have found that soldiers routinely and systematically employed rape, gang rape, and other violent and forced sexual acts against women, girls, boys, men, and transgender people in blatant violation of international human rights law, as indicated by the report in August 2019. This is the kind of competing narratives that Myanmar government puts out as a tool to gaslight the community, in hopes that it would soften the blow from all of the accountability initiatives that has started. It is exactly this sort of...
Thank you, Jasmine. Sorry to interrupt you. I know that there is so much more to discuss, but maybe we can continue a bit later. But I want to give a bit of space to our last speaker also, because he's going to tell us more on something that you just touched on, that is the prevention, how we can prevent those crimes from happening again in this context. So our last speaker is Dr. Daniel Aguirre, who is a senior lecturer at Roehampton University, but he was also the former senior legal advisor for the International Commission of Juries based in Myanmar. Please, Daniel, over to you.
Unmute. Thank you very much. I'm going to be as brief as possible in the interest of time, but I think that there's been some important points that have come up here, and that is that the lowering of expectations of the communities in Myanmar about international justice, but also that there is something very instrumental about this international justice initiatives, in that this idea of stopping violations now, in the meantime, and that the discerning glare of the international community is on Myanmar somehow. And this leads me to start to think about the idea of preventing these violations in the first place. And do we have real developments in international law on prevention here? Of course, an emphasis on prevention is really important. In the Genocide Convention itself talks about prevention. It lists its inchoate crimes. We have huge lists developed by a whole cottage industry of genocide prevention on early warning systems. We have a draft treaty on crimes against humanity. So it's very important that the ICJ provisional measures mention prevention. But I think we need to take a step back here and consider that preventing genocide and its inchoate crimes needs to address the logic of impunity that allows the state actors to consider committing those crimes in the first place, right? Prevention ultimately requires a national system of governments capable of balancing the powers, upholding the rule of law, and ensuring accountability for human rights violations before they become the inchoate crimes of genocide, or before they become widespread and systematic, right? Before they become gross and systematic. And this requires addressing transitional justice issues, and it's also an intensely political issue requiring international cooperation, firm diplomacy at least, and international intervention at most. None of these were forthcoming in the run-up to the crimes in question, whether it's genocide at the ICJ or other international crimes in at the International Criminal Court. But the provisional measures talk about preventing. Will these prevent further crimes. You know, essentially the provisional measures set down by the International Court of Justice ask Myanmar to follow the provisions of the Genocide Convention, which Myanmar argues it always has been doing. It is that deterrent approach, outlaw genocide and its inchoate crimes at the national level. But and specifically in 2 and 3, there's some interesting provisions. It says it says Myanmar has to prevent the military or other groups from participating in genocide or its inchoate crimes. And also it says it has to prevent, in Article 3, prevent the destruction of evidence. It shall not be destroyed or rendered inaccessible. These are important and interesting to look at, but again, we have to sit back and say, in reality, how is this going to be enforced? And what happens in a country that is incapable of preventing the military or where the evidence has already been destroyed? Enforcement in the end will come down to the UN Security Council with all of its own international politics. So far, Myanmar's response mentioned already a series of limited court martials, not independent commission of inquiries, directives encouraging anti-hate speech, ordering compliance with the convention. Of course, we may find out more when we learn what exactly is in the report from Myanmar to the International Court of Justice. And I think where us as international legal advisors, international legal activists, and international lawyers lose track of this is that prevention of these international crimes has to happen at the national level. And at the national level in Myanmar, as mentioned by a number of speakers already, there has developed over decades a logic of impunity, where there's a complete absence of human rights law and a complete absence of its implementing legislation. On impunity and accountability that is lacking in Myanmar. Provisions in Myanmar's law facilitate impunity of soldiers. Military and security personnel seldom face justice for human rights violations, and they're legally protected by provisions of the 2008 Constitution, 1959 Defense Services Act, 1995 Police Force Maintenance of Discipline Law, etc., among many others. These all include immunities, access to special courts that shield soldiers, police, and officials from public criminal prosecutions for serious crimes. On top of that, you have an issue of the independence of the judiciary, or the dependence of the judiciary, I guess we would call it in this case. State officials can routinely violate both international, but especially national laws. The limited avenue for remedy and reparation for state crimes, and the entire system of justice is characterized by violations of fair trial standards. Both the national level standards and international standards are commonly disregarded. Courts themselves are unwilling or unable to intervene in human rights situations or guarantee non-reoccurrence when these issues arise. Prosecutors lack independence to prosecute and regularly instead prosecute, and the entire judiciary harasses victims themselves and human rights defenders using laws such as defamation and unlawful association. And you add to this a state-level legalization of discrimination. You have key laws that facilitate discrimination against minorities, but in particular the Rohingya. You have the 1982 citizenship law, which renders the Rohingya without citizenship and therefore not able to access the rights protected for citizens only in the Constitution. You have the 2014 Myanmar National Human Rights Commission law that renders Myanmar National Human Rights Commission not independent. You have the 2015 race and religion protection laws that openly discriminate between different religions. These were all put in place during, these final two laws I mentioned were put in place during the so-called reform and transition period. Which leads me to ask the question, what about international cooperation and firm diplomacy? On the day the provisional measures were issued by the ICJ, the Chinese government announced billions of investment in northwest Myanmar to support economic development in the country. Working on human rights issues, trying to explain these human rights warning signs to the international community, us in the human rights activists and international human rights organizations were routinely described as being gloomy by the diplomatic corps. And why couldn't we see that everything was improving? And this was all part of an idea of an economic engagement strategy that, got to the point where not just diplomats, but United Nations organizations were afraid to say the word Rohingya in case it meant that they would be less likely to engage with the Myanmar government, and especially it would have an impact on foreign investment. So unfortunately, and perhaps it's a bit of a downer for the developments in international law here, the real solution to this is implementing international human rights law and implementing the standards at the national level that would allow citizens, victims of rights abuses, to challenge government actions before they escalate into inchoate genocide crimes like conspiracy to commit genocide, hate speech or that advocates for genocide. Once you're at that point, I'd argue it's a little bit too late.
Thank you, Daniel. So just very briefly, please I'll ask you to answer maybe in 1 minute or so, because you just told us that the provisional measure ordered by the ICJ are likely in effect in the context of Myanmar. So what do you think would be effective provisional measure in this context to prevent genocide and other international crimes?
Yeah, effective provisional measures are probably beyond the remit of the International Court of Justice, because it directly impacts on the domestic sovereignty of the state. It would be to do what human rights organizations have been advocating for in Myanmar, which was when I worked there, we did a lot of work trying to get Myanmar to sign and ratify the Covenant on Economic, Social, and Cultural Rights, which would mean non-discrimination rights to culture, health, education, livelihoods, and land. Ratify the CERD Convention on discrimination. Most genocide is facilitated by racial discrimination, whether it is in law or in the community. Massive education campaigns on racial discrimination. And finally, sign and ratify the Convention on the civil and political rights that deals with these issues of impunity, fair trials, independence of the judiciary. Myanmar still hasn't signed or ratified those final two, and have diplomacy that emphasizes the need to follow human rights law to the letter, rather than a kind of a policy of strategic engagement that puts international investment ahead of human rights law.
Thank you. And I'm aware that the webinar should end now, but I think we can just run maybe like another 10 minutes, just because the discussion is so interesting. So I'm going to ask all our speakers a very difficult task. So to synthesize in one sentence or two, really like 1 minute each, your conclusion, and possibly based on some of the questions that you received from the audience, which are so interesting. I'm very sorry that we cannot answer all of them. Maybe we start in the same order. So Marco Longobardo.
Thank you very much, Irene. As far as I know, I received two questions. The first is about whether standing based on obligations and governance partners could be recognized in the framework of the Paris Agreement. I think so. I think so. The attitude of Japan in the Walling case could be relevant, because it was about biodiversity conventions. But please remember that that's a second step. The first step is, has the ICJ a jurisdiction based on consent? And in the Paris Agreement, there is no compromissory clause. But if, let's say, there is a way to reach the court, there is a way in which states gave consent to the court, we can say that a state not directly affected by a violation of the Paris Agreement could bring a claim, in my opinion. And the second question is from Bruno about what standing in relation to obligations erga omnes, that is obligations based on CASMA international law that affects the rights of all the states in the international community versus obligations erga omnes partes. I think that this is what was excluded in the southwestern, in the Southwest African cases. The court said that Ethiopia and Liberia, if I remember correctly, did not have standing because they were not party to the relevant treaty. That was the mandate on Southwest Africa. And this was quoted by Philip Sands as counsel of Gambia in order to make a distinction between the position of Gambia and what happened, what was decided by the court in South Africa case. And so this is relevant as opinion juris of the Gambia. So I would not expect the court to open standing in relation to violations of obligations erga omnes as such. I would like this. Maybe this could be constructed upon the dictum in the Barcelona Traction case, upon Article 48(1) of the International Commission articles on state responsibility. But let's say that I don't have any evidence to say that that's likely. And just a final word. Thanks.
Sorry, we just have to move on with this so much. But Marco Milanovich, please, your 1 minute conclusion.
Well, thanks to everybody for the questions, and apologies for not being able to answer all of them. So I'll just try to do a few. There were some questions sort of asking whether the evidence we have, contrary to what I said, could actually lead the court to conclude there is genocidal intent. I would say not on the basis of the evidence that's publicly available. So if you actually read the fact-finding mission's report, it concludes, so all of the factors they take into account existed also for Bosnia and Croatia. And yet the court still did not find genocide, grosso modo, right? If you look at it on an abstract level. And in fact, the fact-finding commission concludes there are reasonable grounds to conclude that there might be genocidal intent. But the requirement of the ICJ is much higher, clear, convincing evidence that there's genocidal intent. And because that you need to distinguish it from persecution as a crime against humanity. And from what we've seen, I don't think that's gonna happen unless the Gambian Council managed to get more evidence. Whether that's Facebook posts, whatever that might be, but I think they need more evidence than there's currently available for there to actually be a finding by the court of genocide. Should third parties intervene? I don't think it'll matter either way. I think the case will turn on what the evidence actually is available. And finally, should Gambia insist on symbolic forms of reparation? Yes, actually. So Gambia cannot claim money because it's not an injured state. But there are many creative attempts at what you can do in terms of reparation that, for example, Bosnia did not pursue. So you'll recall in the Bosnian case, Serbia was found liable for violating the obligation to prevent genocide. But Bosnians council themselves said, all we need is a declaration from the court in that regard. And that's what the court did, and ultimately it was worth little. So that's where there can be some creativity, but that will depend obviously on the issue of evidence. Thank you so much, and apologies for not answering every question.
Thank you, Marco. And over to you, Priya, for your concluding words.
Thank you. I have 3 questions. I'll just answer them very briefly. I think there's one question on whether the jurisdiction of the ICC would change if there was a finding of genocide as opposed to crimes against humanity. I mean, as the pre-trial chamber said, as long as there's a territorial nexus and part of the conduct is committed on a state party, then the door is still open. So I don't see that, that would be an issue. Of course, as Dr. Milanovich has said before, it's a question of the intent and the factual basis. So I think that's more important. There's a question on crimes against humanity, whether they're internally regulated or an international instrument. I mean, as of now, there's the Rome Statute, but there's also a draft treaty that's being prepared and, under discussion. And the last question was on the level of interaction in regard to the ICC outreach process and victims. I mean, I can't speak to this directly, but the one thing that I will say is that clearly there has been a lot of outreach by the VPRS, but of course limited to the refugee communities that are in Bangladesh and, not in terms of access to the many, many survivors who are in Myanmar as well. So I think, thank you very much.
Perfect, Priya. And Yi, please, conclusion from you as well.
Great. I just wanted to touch on one thing which was asked, which was the perception of other ethnic nationalities and ethnic armed organizations towards the Rohingya. The question that was asked was that, you know, you had seen ethnic armed organization issuing statements in support of the Damodar ahead of the ICJ proceedings. And, you know, has that changed around now that you're seeing more targeting? I think that, you know, first I want to clear up even that message, quote unquote, statement of support, you know, because when it came out, many of us, we were quite shocked, reached out to our counterparts and colleagues who work in the ethnic armed organization as to how something like this could have happened, given that many of these ethnic armed organizations have pushed for accountability themselves and have tried to get a federal democratic Myanmar. And the way that it happened was that many were engaged with the Damodar in a sort of a détente peace negotiation. And the Damodar pretty much came in and was told that, you know, you need to stand with us or this peace negotiation is not going to go anywhere. And in fact, within, you know, and they chose a day in which strong members of ethnic armed organizations such as the Karen National Unity, these strong forces that usually are voice of opposition that could match the Damodar were not present. So then some of the smaller EAOs were forced to agree to these terms. And within 30 minutes, a press release was drafted up by the spokesperson of the Damodar. It was already issued out in the domestic media. And I also want to just add, related to that has been sort of this reaction inside and the figure around the state counselor, the state agent at the ICJ proceeding, Aung San Suu Kyi. You know, for many inside the country, for so long when they talk about the democratic movement or what they're fighting for, she has sort of become this sort of symbol. So to have her use sort of her platform to negotiate or make peace with the military to, you know, in the lead up to the election or whatever ploy this may be, it sends a powerful message as far as to the general public, those who are not engaged in the political dynamics, who many see her as the best hope. So when you see a figure like her standing up or a Damodar asking you to sign, many people end up supporting. But really, as I was saying in my presentation, the communities who are affected, the people who are calling for justice, that's never gone away, and that's still very much there. And I think that touching on what Daniel said before, you know, we wrap up, is that as the international community, people owe an obligation to think to use all the tools at their disposal to not let, you know, the powerful allies like China and Russia shield this junta from this culture of impunity. And there are tools that the international community is not using beyond international accountability, from travel bans to, you know, hit them where the money hits. Yasmin talked about economic sanctions. These are a long range of tools that has not been used. And I hope that we can use international accountability, work within the country to try and reform so there's actual genuine rule of law, while still applying pressure using these non-legal means. And I think I'll just leave it at that.
Thank you, Yi. And Jasmine, please, just a short conclusion from you as well.
Thank you. I wanted to touch on this earlier, but the time didn't allow. And I don't think that I can see the question anymore. So if anyone actually have any question for me, please feel free to reach out to me outside of this. But what I want to leave you with is that there are a lot of survivors and people that are at risk of re-victimization that cannot wait forever for the international justice that we're all talking about. And many panelists talked about, you know, the various other tools that there is for us to actually break down the culture of impunity that exists. And I would like to suggest this. Justice can mean many things, and I think that there is it has come a time that we actually need to kind of think outside the box and think a little bit more along the line of restorative and transformative justice. It cannot just be, you know, about Myanmar and how, you know, the current status quo will prosecute the case, or, you know, the outside force, UN courts will prosecute the perpetrators, but it has to come from the changes within, and it has to, you know, come from the voices and the reclaiming of the power by the people of Myanmar themselves. You know, Rohingya ourselves, we cannot just wait for, you know, another 10 years for a ruling to come down and saying, you know, whether or not this is a genocide. We actually need your support now. And the support can be very tangible things like humanitarian aid, donations, or the capacity building of our leaders and civil society. which is going to help in rebuilding our community later on, past this, all of the initiatives, all of the justice mechanism. Beyond that, we need to be able to imagine and rethink for ourselves what we want to see in our own community, and what, how we could, build up our own strength to rejoin the country, or to have another alternative to exist as humans. Thank you.
Thank you. This is great, Jasmine. And finally, Daniel, please.
Thank you. Well, there's not really much to say after Yasmin's points there, but in terms of developments of international law, I think all of us international lawyers really, without taking away from the importance of deterrence in international criminal law, when it comes to preventing these crimes, have to recognize the importance of international human rights law and its implementation at the national level. Myanmar is a perfect example of a country unwilling and unable, for a variety of historical and present reasons, to implement international human rights laws at its national level. And it is a perfect example of the failure of the international community to make that a priority in the run-up to this terrible situation, when they had every single possible warning sign was prevalent. And we're told, personally, I can tell you that this was coming. And so I really think that that's an important issue for us to address in the future on prevention, is the focus on human rights. And I want to thank everybody for this really interesting discussion, and just quickly say, I wish we were now stepping out of Bickel's wonderful office into Russell Square on this fine sunny day.
Yes, exactly. I wish that too, and that will actually have allowed me to be there with you. Although it's great that we can have also people join from other parts of the world. But sorry that this webinar has run a bit late, and again, apologies for technical problems that not allowed me to show my video. And from Bickel, many thanks to our brilliant speakers. We'll have so many things to think about. We can follow up on the discussion. Marco Longobardo, Marco Milanovich, Priya Pillai, Yetu, Jasmine Hulla, and Daniel Aguirre for the conversation. And many thanks to you, of course, in the audience, for participating and for your questions. Sorry we were not able to answer all of them. Just a reminder, the webinar has been recorded, and the video, as well as link to the material, will be available on the Bickel website. Please, if you enjoyed today's webinar, also an appeal from me, please consider making a donation to support Bickel, because we rely on donation, event income, and research grant to deliver our activities, including this event. Thank you very much.
Thank you. Bye.
Bye-bye. Thanks.
Thanks. Bye.